Hi, everyone. Welcome, and thank you for joining the National Down Syndrome Society's webinar, Optimizing the Use of ABLE Accounts and Special Needs Trusts. Whether you're a parent, sibling, professional, or friend, your role as a caregiver matters deeply, and we're excited to have you with us. This is the 6th webinar in our Caregiver series, which is happening throughout the month of October. Be sure to check out our website for additional webinar offerings in the series. My name is Jessica Kuss, and I'm the Director of Community Programs here at NDSS. Before we dive into the webinar, I'd like to go over a few housekeeping items to ensure that everyone has an enjoyable experience. If you experience any technical issues during the webinar, please use the chat function to notify our support team so we can assist you. Our presenters will answer questions at the end of the webinar and in the chat throughout, so we encourage you to submit your questions using the Q&A feature or the chat near the bottom of the screen. We'll do our best to answer as many as possible. If we're unable to answer your questions during the event or you have a specific question, we will be sharing contact information towards the end of the webinar for you to contact. Please note we will not be using the raise hand feature. This webinar is being recorded and will be shared on the NDSS YouTube channel and NDSS website within a few days, and you will receive an email with that link and links to any of the resources that we mentioned. Thank you for your attention, and it is my pleasure to introduce Mike Walther and Randy Gillespie of Oak Wealth Advisors, who will be presenting today. Thanks so much for joining us.
Thanks so much, Jessica, and thanks so much to NDSS for hosting us during Down Syndrome Awareness Month. We certainly band together with your organization to try to celebrate all those in the Down syndrome community, whether they're an individual with Down syndrome or whether they're an advocate, supporter, family member, or loved one who are supporting others. Great month, great time to be sharing information. And with that, let me get right to the slides and start sharing the information that we have that we want you to go away with after today. So a focus of our discussion today is going to be on ABLE accounts and special needs trusts, and specifically on how to optimize them. I think many of you know these things exist. We'll give you some of the background information, but the focus of our discussion will be on helping you make the most of these two planning tools for your family. A picture on our lead slide is my brother and I last year during the holidays. I've had a loved one in the disability community in my family for over 55 years. Absolutely a joy. Love him very much. We're going to be, partnered together for the rest of our lives. And I think in the Down syndrome community, it's very similar, right? Your loved ones will be part of your family forever. It's not as if that child becomes an adult and moves away and becomes a distant relative. Nope. In a Down syndrome family, that loved one's going to be really a focus of everything for the long term. And I get that. And everyone at Oak Wealth Advisors has a loved one in their family with a diagnosis of something in the disability community. So we get it. We're living it with you. And in fact, I'll introduce my colleague Randy Gillespie in a minute. She's got a daughter with Down syndrome. So with that, let's look at who we are. I founded Oak Wealth Advisors 18 years ago after working with very wealthy families, making them wealthier, realizing that I wasn't really making a difference in their lives. But being able to help families with disabilities and diagnoses that require additional planning has been an absolute joy. We've been able to get some awards recently regarding our ability to bring inclusive exposure to those families with disabilities into the planning community. In addition, we've also been awarded some things for our expertise with financial planning. So our focus is in helping families like yours get the information they need to make better decisions. Randy, as I mentioned, has a daughter with Down syndrome. She was a former family support coordinator, basically the first point of contact for families when they're going to be diagnosed having a daughter or a son with Down syndrome, typically right at the hospital at birth. She'd get those phone calls. She was an incredible advocate then, and she is today for those families and many other families in the disability community. In fact, she's done work outside of our office. So despite working a 40-hour week, helping families all over the country with different needs and challenges, she also works in the community to educate through the school system and with the village to increase awareness and opportunities for those with disabilities. So as we talk today, the majority of my discussion will use what's called person-first language. That is saying the young person with Down syndrome, not the Down syndrome girl. That's important because we want to make sure that they're respected as an individual first, and they just happen to have diagnosis of Down syndrome as one of the things that's part of who they are. In some situations, we encounter families and individuals who are really proud of their diagnosis, their condition, and they want to put that first and use identity-first language, and that's totally fine. In those meetings and those discussions, we'll honor that request. But today, for the most part, I'll be using person-first language, and if I slip and use identity-first language, please understand I'm not meaning to offend anyone, but we want to make sure everyone feels included and understands that we're coming at this from a good place. So what is it that someone like us can teach a family like yours? Well, what special needs planners should be doing is helping families find and keep public benefits. That's the base core benefit we're trying to get for our loved ones that allows them to get additional resources, financial and other supports from the government, in addition to what the family can provide. We want to make sure we're planning for the ongoing care and support of that person, not just today, but what they're going to need in the future, and structuring options for them to remain as independent and successful on their own as they can be. Everyone's different. We always discuss that if we know some person with Down syndrome, we know one person with Down syndrome. Everybody's unique. We don't assume anything just because we work with hundreds of families. Everyone's going to have their own challenges and their own abilities. We want to make sure they're finding additional resources in their community, working through organizations like NDSS to find good information and find a peer network to learn from. And then helping families protect their loved ones from individuals who might take advantage of them. And we'll talk about how special needs trusts and ABLE accounts work in that environment of protection. And then finally, advising families on what kinds of structures they should have with their planning to ensure that when they pass on, their assets can be most effectively transitioned to the benefit of their loved one. Okay, so that's what the role will be. And you'll see some of that come through in the conversation about ABLE accounts and special needs trusts today. So as I mentioned, the core of the planning is to get access to and maintain public benefits. For those of you with younger children, those benefits are going to be provided through your public school system through the year in which they turn either 21 or 22. The one outlier being Michigan. If you're tuning in from that great state, well, you can go through age 26. That's the only state that goes beyond 22. Most states are 21 or 22. The big challenge for most families that we're encountering is what happens when those school supports stop. So that's going to be where some of these benefits come in, right? The Medicaid waiver services, those provide a lot of the day supports that the person might need for ongoing education, for vocational supports, for day activities, whatever it might be that they need, even respite for the parents. Those come through Medicaid waiver services. We only get if we're eligible for it when we plan correctly. And it's not easy. As you may be aware, roughly 60% of all families who help their loved one apply for these means-tested government benefits, the income benefit of supplemental security income, also known as SSI, and Medicaid, which is both health insurance and waiver services, 60% are denied. That means only 40% are going to get those services, oftentimes because of simple mistakes in the application process, not knowing the rules in advance. So really important to understand that once you get them, we want to keep them in place. We want to talk about how both ABLE accounts and special needs trusts, often called supplemental needs trusts, can be absolutely invaluable in keeping benefits in place. And you got to remember that with all of this in the disability community, record keeping is absolutely essential. We want to have good records when we go and apply for benefits, and we need to maintain good records about how we're spending the money on behalf of our loved one as they get older. And if you're the trustee of a special needs trust, you've got to document every distribution. So very important as we think through all this planning that we think about our own abilities and our own administrative functioning skills to provide that support. And if we're not great at those things, look in the community and find out who else might be helpful in assisting with the administration and documentation of all these different benefit rules. Okay, as I mentioned, the state limits for age, the majority of the country, you're able to keep benefits through the school system through the school year in which your loved one turns 21. So they turn 21 in the summer, not part of the school year, they're done. They will not get another year of support. If they turn 21 and they're in a purple state, let's say September through April, they need to finish out that school year into May or June, whenever your school system ends. That's a nice benefit. If you look there, there's only a few states that stop on a 21st birthday. Most go to the school year in which they turn 21. And if few are green, that's the 22nd birthday. Blue is the year in which they turn 22. That's to 22 plus. As I mentioned, Michigan is the outlier. If you really want 5 more years or 4 more years of school supports, you can move to Michigan. Okay, so with that, we'll give you this slide as kind of a keepsake, a little summary of government benefits. Today's focus will be on the trusts and ABLE accounts that support these benefits. We want you to have this as a reference. The bottom tier in gold are the means-tested benefits, those that are available for someone who is both poor and disabled. And poor by the government definition means they have less than $2,000 of financial assets other than a car and a house. They can have those assets as well, but less than $2,000 of available resources. and they're not able to work at a substantial gainful activity level, which is roughly $1,500 a month. If your loved one qualifies under those parameters, they should be able to get an income benefit that I mentioned earlier, SSI, Supplemental Security Income, of $967 a month. That gets reduced if they're getting free housing from a family or a landlord in some form. And then they get Medicaid, which is both the healthcare support as well as the waiver services. That's what's available if you're poor and unable to work. The blue level benefits are for those who have worked, either as a result of their unemployment or when they're older and a parent retires, they can receive benefits off a parent's work record. And they can get SSDI, which is Social Security Disability Insurance payments, which is effectively an early start to your normal Social Security retirement benefit, and Medicare, a different medical program that covers things in many cases more thoroughly than Medicaid, but does not provide things like long-term care. So if we think our loved one might need assisted living at some point in the future, we want to make sure they stay eligible for Medicaid, because Medicare, at least under current law, is not going to provide that. And I should probably pause here to say that everything we're talking about today is general information. It may change tomorrow based on how fast the government's moving and changing things. We know the numbers will change as of January 1st. So don't take all this as, locked in stone, but this is the current parameters for how benefits are available to our loved ones. And also understand that as I walk through these other benefits of trusts and ABLE accounts, they may not be appropriate for your family, but at least I want you to be aware of what those things are and how they would apply, and then you can make the decision if it's appropriate for your loved one in the future. So I mentioned the exemptions. This is all your loved one can have direct access to and still get the means tested benefits, the SSI and Medicaid. $2,000 of assets other than a home, household goods, a car of any value, and then life insurance, which is a very limited amount, maybe $1,500, similar for prepaid burial funds, and then any property they might use to operate a business. So if they're going to be working, whatever their equipment is, that kind of stuff, you can have that as well. So from a planning perspective, when we look at that, what it really says is they can't have anything. It's really zero. That $2,000 number has never been indexed by the government. One of the very few places within the Social Security overview of benefit plans that the number's never been indexed. That's about a 30-year-old number. So there's lots of advocacy around making it $10,000 just because the government looks at that number every single month on the last day to see if your loved one all of a sudden has assets more than $2,000. And as soon as they identify that, there's going to be a loss in SSI payments until that gets rectified. Oftentimes it's from an oversight or a simple mistake. So from a planning perspective, we would tell you, try to keep their access to direct available funds as close to zero as possible, because they get a gift. If they've got access to an account, you can easily go over $2,000 and you add those things together. So working to keep that number as low as possible is really important. And ABLE accounts and special needs trusts are a huge tool for making that happen, because those are going to be exempt. Those will not count towards that $2,000 limit, as we're about to see. So we'll start with special needs trusts. We feel very strongly about that very first bullet point. Oftentimes families will come to us and say, oh, you know what? I've got a neighborhood friend who's an attorney. They helped us with our closing documents when we bought the house. We're good friends. We're gonna have them do our special needs trust. I think that's a mistake. In almost every case, you wanna work with a specialist, an attorney in a firm that work in this space, who know exactly what the Social Security Administration review process is gonna be looking for in the document. Because that, at the end of the day, is what we're really trying to draft a document to do. We're not attorneys. We work with lots of the best attorneys all over the country who do this kind of work. If there's certain language that an attorney who's not familiar with this puts into a trust, just not understanding that sentence or phrase might jeopardize the entire document, then you have a problem. You just spent thousands of dollars for estate planning documents that aren't going to achieve your goal. Your goal is to have these documents meet the Social Security Administration's threshold for being a qualified special needs trust. One of the biggest things that's going to qualify it is that the individual can never demand or automatically get distributions from the trust on an ongoing basis, only at the trustee's discretion. The trustee is the person who makes all the decisions related to the money and the assets in the trust. If the trust has any other stipulation about distributions being available to the individual, the government's going to count all the assets in the special needs trust as available to the individual. That violates the whole purpose of having the special needs trust in the first place, which is to allow money to accumulate and be available for your loved one and not count towards that $2,000 asset limit. So, as I mentioned, there's no limit to how much money a trust can hold. We've seen families with millions of dollars fund a special needs trust or have intentions to fund a special needs trust that'll have millions of dollars in it for their loved one's future care. And in some cases, they might need that much. In other cases, they're just making sure that their loved one never loses the Medicaid supports by making that dollar amount available to the individual, which might cause Medicaid and SSI to go away. So the trust becomes that vehicle to hold the money to maintain eligibility. The trustee has sole discretion for distributions. Really important distinction. A special needs trust is really just another account. So think of it as you might have a joint account, you might have a retirement account. Your loved one's going to have another account called a special needs trust. And the person making the decisions for that is not the individual, it's the trustee. It could be one of you on the call. You could be the trustee for your loved one's trust, but you don't have to be. It could be a corporation, it could be a professional fiduciary, it could be any individual that you name to play that role. It could be either a company or a person. Okay, but that person known as the trustee will be the one making the decisions of making distributions and paying for things for your loved one, who's known as the beneficiary, the person who benefits from the money in the trust. Okay. Also, we'll circle back to this with more detail. When we're putting designations down for beneficiaries on retirement accounts and life insurance, and we're going to have a special needs trust for our loved one, we want to name their trust and not them outright by name on those beneficiary forms. That will ensure that the monies go into the trust and remain available for the individual, but they don't jeopardize their benefits by putting it directly in their name, where all of a sudden it's an available resource and it counts towards the $2,000 limit. And now we're losing SSI and Medicaid. Okay. Now we're looking at 3 different kinds of trusts. The first is the special needs trust we typically think of. We're talking about this kind of planning with a client. That's a trust that's going to be funded by anybody's money other than the individual. So it's a third party, not the individual's own money, other people's money. So anybody can fund this. It can be a parent, grandparent, relative, friend, anybody can fund it, except the individual can't put their own money into a third party trust. All trust, all special needs trust, no matter how much money they have, will be exempt from that $2,000 provision of how much a person can have direct access to. Okay. Distributions have to be made from these trusts for the benefit of the individual, but they cannot be distributions directly to the individual. So let's say that your loved one wants a new iPad. That's going to cost $1,000. The trust can pay for the iPad directly. The trust should not make a $1,000 distribution to your son or daughter to go to the store to buy the device. Okay, because at that point, the child has access to the $1,000. That's going to count towards your $2,000 limit. And by chance, they might be over the limit for the month. They'll lose benefits. So we're going to have the trust pay directly for things. You can set up automatic payments. You can do lots of things to make it easier for the trustee to make multiple payments for your loved one. We don't want the trust distributing directly to the individual. And with a third-party trust, as I mentioned, it could be millions of dollars in that account. That's all fine. No matter how much money is there, the person who set up the trust, typically a parent, but it could be someone else who establishes it, they can designate a successor or future beneficiary. So after your loved one passes away, if there's money in that trust, who gets it? Well, you can designate. It could be a charity like NDSS, shameless plug there, or it could be anybody you name in your family or other people you want to get that money if your loved one does not spend all of it down during their lifetime. There's no government reimbursement at death. Very important concept there. So in my example, if someone left $1 million life insurance policy and the individual passed away before they spent much of any of it, there might be $1 million going somewhere. And that can be distributed based on whatever the family designates. That's a distinction relative to the other 2 kinds of special needs trusts. So the next one I want to talk about is a special needs trust funded by the individual's own money. Maybe your child's older. Maybe they're in their 30s or 40s and you and your family are doing a great job saving for their benefits. And you now want to go get the means tested benefits of SSI and Medicaid. You weren't aware of those, you know how to apply, it's just been too busy, you haven't gotten it done, but all this money's been accumulated in your loved one's name. And you just learned you can only have $2,000 in their name. Like, what are we going to do? We can't spend that much money in a short period of time. We want to get the benefits put in place sooner rather than later? Well, if they've got $40,000, $50,000 in their name, you can take that money and create a self-funded trust, also known as a payback trust, for the point you see on the bottom bullet there, which is that the monies that go into the self-funded trust, which is the individual's own money, if those dollars are still in the trust when the individual dies and they'd received Medicaid services during their life, the government, which obviously doesn't keep budgets very well, is very, very good at keeping track of the benefit value of the Medicaid services received by your loved one. So they'll put a claim to your loved one's estate and say, look, you know what, we provided $120,000 of services. We want the $50,000 sitting in that payback trust, and they're going to get it. They're the first beneficiary on a self-funded trust. So in some cases, we got to set these up because the individual got money in their own name. We have to get it out to keep services. Well, the self-funded trust is a good solution for that. It can hold the money. You got a third-party trustee making those decisions, just like on the traditional third-party trust. The trustee rules are exactly the same. The individual, even though they put their own money in, they don't have any demand rights to take it back out. The trustee is still the decision maker. And that's why the government allows you to move any amount of money into a self-funded trust and keep benefits the next day. Normally, like, wait a minute, that's crazy. You're gonna give me back my benefits in one day if I use this trust? Yes. So it's a good planning tool if the child's got too much money to go get benefits and you want to get benefits started really quickly. Put the money in this trust and then spend it down, right? Use these funds first because there is a requirement to reimburse the government if your loved one's receiving Medicaid services. So if you think about it, you've got $500,000 in the third-party trust funded by other people, let's say $100,000 in the self-funded trust funded by your loved one's own assets. Spend the full $100,000 first in that self-funded trust before you spend a nickel of the third-party trust. There's no requirement to do it pro rata. There's no requirement to do it based on which one was funded first. We want to spend down the one that has that payback requirement, because if that self-funded payback trust has $0 in it when they pass away, and the third-party trust still has several $100,000 in it, the government gets nothing. They only have rights to the money in a payback trust. And there's one other trust I want to bring to your attention. Let's say we don't have hundreds of thousands of dollars at some point from life insurance, retirement accounts, sale of a house. There aren't those kind of resources in your family. But you still want to have professional guidance in the form of a trustee making these decisions for distributions. There's another solution. It's called a pooled trust. Sometimes funded and oftentimes funded by the individual's own money, often when there's no other relative around to help manage and support that individual with financial decision making. Pooled trusts are all run by nonprofits in a state. So each state's going to have anywhere from 2 to 4 or 5 pooled trusts you can choose among. They're all going to basically take lots of smaller accounts, bring them all together, create one investment pool, thus the name for the trust, the pooled trust. And with that, you can get more cost-effective investment management and trustee services by taking lots of $10, $30, $50, $100,000 accounts and creating one $5 to $10 million pool, which then uses fancy accounting to make sure that each person only is eligible to take out distributions from their share of the total. But it's being managed as if it's one. So there's accounting that makes sure that nobody gets more than their fair share, but the costs are much less than trying to find a trustee to manage a very small trust when the trustee fees will eat up the total balance in the trust rather quickly. So you can look at your own state, type in pooled trust in, fill in the blank name of the state, and you'll see your trust options there if that's of interest to you. And again, it could be set up and funded by the parents, other relatives, or the individual him or herself, but on a pooled trust, in almost all cases, and it's not true for every state, but for most states, either the pooled trust itself or the state in which the Medicaid services are received will be the beneficiary of any money left in your loved one's share of the pooled trust. Randy, any questions? I should have also said, if you have any questions, please put them in the chat, and Randy will try to answer those questions in real time as best she can. If there's things to interrupt me with, she'll stop me and we'll go back and readdress something.
I think we're good right now.
Okay.
I'll circle back. I'm answering some right now. We're good. Let's keep going.
Super. All right, we'll keep firing them to Randy. She'll do the best she can. If she wants me to stop and talk about it, she'll do that.
Got it.
All right. So what is a good trustee? Oftentimes families will come and see us and they're going to assume that a parent or a sibling or some other relative is going to be the trustee forever. Okay, fine. That often is a cost-effective way to do things because oftentimes the relative won't charge a trustee fee, which will run anywhere from, let's say, 1.5% to 2.5% of whatever money is in the trust every year. So it's not an inexpensive proposition to have a professional trustee in place, but the reason why they're charging those kinds of fees is because they've got a lot of responsibility, including staying in communication with your loved one and knowing what their needs are and getting those paid quickly and effectively. Investment management. The trustee has to take care of whatever assets are in there. It could be financial investment assets. It could be real estate like a house. It could be a collection of something. Whatever it might be that the trust owns, the trustee has responsibility for that. So if the trust owns the house the person's living in, the trustee's got to be responsible for making sure utilities are done, maintenance is taken care of, taxes are paid. So there's a lot to deal with there administratively for the trustee. They also have to file all the statements. The trust is its separate taxable entity. So if the trust assets generate income, it's got to file an income tax return. Even if the trust makes distributions and effectively will not owe any tax because as it makes distributions, that passing out of the money to pay for things passes out the income to the individual. This isn't meant to be a tax class, but effectively the individual, him or herself, will likely then have to file their own tax return. They may or may not owe any tax, but the trust has to file the tax return either to pay the tax or to show it distributed money out and now the individual's got a tax consequence. Okay, and the trust laws are always changing. Right, just this past year, we saw a couple positive changes for the disability community that came through for planning. Well, you want a trustee who's aware of those things and can take advantage of them for your loved one. So these are all the characteristics of a good trustee. Having seen those, give some thought to whether or not you or someone in your family has all those skills and qualifications and desire to do those things for your loved one as the trustee. Or does it make sense to look for and interview some professionals who can play that role? Because one of the biggest challenges we see with special needs planning is that often our families will tell us, well, this one person is going to do all these different roles. Okay, let's say they're Superman and they can do all those things. That's great, but Superman won't live forever. At least I don't think that's part of his characteristics. So we need to find somebody who can step in or an institution that can play a role if that person quits, dies, gets frustrated with it, doesn't want to do it anymore, moves away and can't do it for location reasons. So we want to make sure we've got a backup solution. So in creating a special needs trust, we want to make sure we think about successor trustees. Who else can do this? Who else would have skills built into their company operations to be a good trustee? We don't want to just leave it all to one person in the family and let them just guess about who should be next. So what can a trust pay for? We should probably be updating this slide because the rules have gotten a little bit easier for trustees to make distributions. It used to be more tight regarding medical types of things. You could always pay for dental and optical care and skilled nursing, but you can even pay for more medical things now. And I'll get to that in a minute. Also, anything related to travel, recreation, education, cultural experiences, basically put fun in air quotes there, right? Anything the person would want to do, yes, the trust can pay for that. Because what is it that the trust was initially set up to do? To supplement what the government provides. The government will provide income that's supposed to cover rent. The government will provide health care in the form of Medicaid. And another program, which is a little easier to apply for, is the Supplemental Nutrition Assistance Program, or SNAP, which provides groceries, so basically food. So if we're going out to a restaurant, the Supplemental Needs Trust can pay for that. Supplemental Needs Trust probably shouldn't pay for groceries. We should use a SNAP card for that. So lots of distribution opportunities here. As I mentioned, what should other sources be used for to pay? Well, groceries, let's use the SNAP card. We can get roughly $300 a month in food. Let's have our loved one use that benefit. You know, it's $3,600 a month or thereabouts. Nice benefit. Over a 50-year lifetime, you now see that's a $150,000 to $250,000 value in food by being on the SNAP system. And roughly a fourth of the country is utilizing a SNAP card somewhere in their family. Medical care. Basic hospital expenses and medications should be paid for through Medicaid. If Medicaid won't pay it, then the Special Needs Trust can pay for it. Okay, we don't have the trust paying for basic routine hospital visits, doctor's visits, things like that, that Medicaid will pay for, because we want to jeopardize the trust. So we want to make sure that it's only paying for things that Medicaid has been asked to pay and said no. Then basic housing expenses. This is a planning tip. If we're receiving supplemental security income, the $967 in current year total income, more in some states. We understand some people will be on this call who are in states that supplement that number and you get more than 967. But 967 is the federal base amount for SSI. If the loved one is living in your house and you're not charging rent, or they're living somewhere else and some relative owns that property, or there's a landlord lets them live there for free, they're going to lose 1/3 of that SSI payment, or roughly $335. So what we want to do is have our loved one sign a rental agreement saying, look, I want to live in the family house. I'm willing to give you $400 of my monthly SSI check, or at least more than 1/3, so at least the $335 or more every month. And then the parents, if they're the landlord, they collect the income from rent. They've got to report that as taxable income, but they can offset that taxable income with their cost of providing the lodging, right? Their utilities, real estate taxes, maintenance to the house. That can offset the rental income based on that person's share of expenses. In most cases, the families don't have any net income to report, but they're hoping their loved one keep that full payment at $967, and they can take that rental payment and spend it for their loved one. They can put it in an ABLE account, or they could put it in a special needs trust. We'll talk about which one might be most appropriate, but they don't have to keep that money. They can go back and spend it for their loved one. It's not a requirement that they hold on to it forever. So that's a way to make sure your loved ones get the most benefit from SSI. But those basic housing expenses need to be covered by your loved one through a rental agreement. And now, thanks to the recent law that was passed, as long as they're paying 1/3 of the SSI amount, no matter what state they're in, the trust and the family can cover the rest of the rent without jeopardizing the SSI payments. That's relatively new. That changed October 1st of last year. It used to be in most states, if the individual, him or herself, didn't pay the fair market value of rent in whatever the location is, then they could lose benefits if a relative paid to support them there. And if you live on either one of the coasts or in a city like Chicago where rent's going to be more than $1,000 a month anywhere you want to live, that's a problem because you only get $967 to spend. So good planning opportunity there. Pay rent, make sure it's $350 to $400 a month, and you should be fine. So as a summary, a special needs trust is a legal document that creates an account that's truly the cornerstone of the planning for your loved one, because it can hold an infinite amount of money and not jeopardize their benefits. But going to see an attorney to get the documents done is not the end of the process. We've had lots of families come and tell us, oh yeah, we did all our planning. We've got this huge binder of documents. We're done. Like, okay, you've started. That's a good step in the process. You have to have the documents, but you have to implement them. We're going to talk a bit more about that later on, but getting the documents done then requires beneficiary changes, requires accounts to be opened. If we don't do those things, we don't really have a special needs trust. We have the template for it, we have a written document, but we don't actually have the accounts to use. And it's also important to understand that when good drafting is done for a special needs trust, there's a little flexibility baked in there to allow for changes when the laws change. We know laws are going to change, and our loved ones are going to live a long time. So in order to do the best job with special needs trust planning, we want to make sure there's some flexibility there that if the laws do change in terms of what distributions can be made, how much money can be given to the individual, things like that, we're able to adjust the trust to reflect that. Okay.
Excuse me, Mike.
Yes, Randy.
Sorry, one quick question, and it's just a thorough answer. Do parents have to claim the monthly SSI rental amount on their taxes?
Great question. So if you're setting up, as I just described and suggested, a rental agreement between you and your loved one who's living there in the house with you, yes, in my example, if it's $400 a month and it's for 12 full months, you've got $4,800 of income. That goes in your tax return, where you're going to basically report rental income, but you also can report the rental expenses. So as I mentioned, real estate taxes, utilities, maintenance, mortgage payments, all that stuff is your expense of maintaining the household. Well, let's say there's 3 people living there. Your loved one's one of them. She or he is the one paying the rent. You can allocate 1/3 of those expenses against your $4,800 of income. My guess is it's going to probably wipe out all of the rental income and knock it below zero. you're not going to need taxes to pay, but it is reportable income. Yes, good question. All right, so the next thing to remember is that you've got these documents. You're going to have a special needs trust. Good. You have to tell people. Tell the extended family, hey, you know what? We just worked with an attorney. We spent thousands of dollars to get this planning done. We're really excited about how it's going to really support our loved one in their future. If you've got intentions to leave any money or any assets whatsoever directly to our loved one, here's some language our attorney gave us. Please work with your estate planning attorney to implement that. That might be a matter of having a grandparent change a beneficiary on a life insurance policy. It might be having them change their own will or their own trust document to reflect the name of your loved one's special needs trust and not them directly. We want to avoid money coming into them in their direct name. We want the assets from estate planning from other people to go directly to that special needs trust. Okay. Also, beneficiary designations. If we're doing this live, I'd ask for a show of hands, asking how many people believe that their will direct where all their money goes when they die. Inevitably, half the room or more thinks their will is going to do all that. Well, it won't. Sadly, that's a misnomer. You might have your will say, I want all of my assets when I pass to go to my loved one with Down syndrome, and it's going to go in the form of a special needs trust, and here's exactly the name of that special needs trust. That's great. That captures the things that pass through your will. However, any account that has a beneficiary designation is not going to transfer via your will. It will transfer directly through a beneficiary designation. So think life insurance, company retirement plans, IRA accounts, all those kinds of things have beneficiary designations, and oftentimes are the largest financial assets we leave to the next generation. So to make absolutely sure that if our daughter Maddie has Down syndrome and has a special needs trust created for her, that we don't name Maddie directly on life insurance or on those retirement plans. Rather, we name Maddie's special needs trust as the beneficiary. That way, if there's $10,000 or $10 million coming to Maddie from those accounts, it's going to go to her trust for her benefit. If it goes directly to her, there goes her SSI and Medicaid supports. So we don't want to do that. We make sure it goes directly to the trust. And then we want to make sure that the trust is a standalone document. And I'll explain that in more detail. But sometimes we see families whose attorneys think they're really quick and smart, and they're going to say that as part of the parents' planning, they're going to create what's called a revocable living trust, basically an account for parents to put money in so that when they die, it goes very efficiently to the next generation. That's great. That's an efficient planning tool. Or they'll say in the will, upon my death, create a special needs trust. So those are special needs trust embedded in other family estate planning documents. Well, what's the problem with that? Well, if we have our trust as a subtrust for a revocable trust, or the subtrust is created in the will at the death of the person who created the will, what happens when some other relative wants to leave money to a special needs trust that hasn't been created because it says, upon my death, create this trust? That's a problem. In addition, if you go to the Social Security Administration and they ask you, hey, is your loved one going to have a special needs trust now or in the future? If so, we need to review that document. And I mentioned how important it is that the attorney drafting it knows how they review those to make sure you don't have a document they're not going to like. So we want to make sure that we're only giving them the special needs trust document. If it's embedded in some other family estate planning documents, we have to give them all that. So there's a loss of privacy. What about the family excluding someone? That's totally okay to do in estate planning, but now you just told the government that. Maybe that's awkward. In addition, let's say that your traditional trust doesn't have special needs language because it doesn't need to. It allows for all kinds of distribution flexibility. Good. Your special needs trust can't have that language. If the person at the Social Security Administration doesn't understand that they're reading your revocable trust that then creates a special needs trust, and it's all in one big set of paper they're reviewing, because they've got thousands of things to review, they might say, oh, that's an illegal distribution provision, denied. And now your kid doesn't get benefits. That's not what we want. So that's the risk, that having a big document that has a trust in it gets read incorrectly by someone who's under a lot of stress and time pressure to review a lot of documents, and they get it wrong. If all they have to review is the special needs trust, much higher likelihood that it's written well, your kid's gonna get benefits. So keep that in mind when you're working with an attorney. Tell them, I want this trust to be a standalone document, so it's all I have to share with the government, that I can fund it at any time, because if any relative says, hey, I want to leave money to your kid tomorrow, okay, we've got a trust ready to receive that. Nobody has to die first if it's a standalone document. Hopefully that makes sense. So how's it going to be funded? Well, every family on today's call has different resources. Some of you might own a house. Some of you are renting. Some of you might have significant financial resources. Others you won't. No problem. The question is, what's the best asset to put in a special needs trust? Well, oftentimes people will use life insurance because it's just a dollar amount that lands it. It's easy to manage. It's cash. You can invest it. You can do whatever you want with it. It's a cash tool when it lands. The trick there is, if we're going to use life insurance, and we don't sell life insurance, but if life insurance is going to be your solution, make sure the policy that you're intending to leave behind to fund the trust will be there no matter when you die. Why do I say that? So many families come and see us and they've got term life insurance. Lovely, great, an important planning tool for a family. Term life insurance should be purchased to cover lost wages of a breadwinner in the family who dies before their normal retirement age. That's going to cover the lost wages. It fills that in. Why do I say that? Because term life insurance is normally not available or is prohibitively expensive once we get up past 65 or 70 years old, normal retirement age. So if we're expecting our loved one's going to live or be alive once we're into our mid to late 70s, and all we have is term life insurance, and that's going to fund the trust, we don't have a funding mechanism. There's no money going in the trust. So give that some thought. If all you have is term life insurance, you're not going to be funding the special needs trust unless you die before normal retirement age. We'll need some kind of permanent life insurance policy. Lots of different flowery names of different companies, but whole life, variable life, universal life, those are the core component names that we'll see in these types of permanent policies. And in many cases, we'll recommend to families, they do a second to die policy. The thought is, we don't really need that policy to pay off for that loved one's trust until both parents are gone, assuming that one parent would do anything possible to help their loved one while they're alive. We really don't need the money until they're both gone. And oftentimes, a second to die policy is significantly less expensive than a permanent life insurance policy on one person's life. So that's your life insurance planning tip for the day. It's often a great way to fund a special needs trust, but please don't think that if you've got term life insurance, that's going to be a great solution. It will not be. Okay, ABLE accounts. We're going to spend the last 15 to 20 minutes going through the newer planning tool. Special needs trusts have been around for 30 plus years. ABLE accounts were passed into law at the end of 2014, and the first accounts became available in 2016, so we're nearing the 10-year anniversary. Very exciting. For those of you who went camping back when I did back in the 70s and 80s, we all took Swiss Army knives with us to basically have one tool that did lots of things. That's how I think about an ABLE account. Depending on your loved one's abilities, challenges, needs, and goals, an ABLE account can do different things for different people. It is easy to open and manage. All you have to do is go to the state ABLE website that you're hoping to open the ABLE account from and log in, type in some answers, the account gets open, you fund it. It's that simple. In fact, you cannot go to a bank or financial institution and have them do it for you. That's not allowed. The individual, him or herself, or a family support person has to be the one to do that for them. So any caregiver can do it with them, and parent, sibling, that's all fine. ABLE accounts are great because unlike the special needs trusts that are taxable, an ABLE account is tax-free. It's tax-free for growth and it's tax-free upon distribution. So it's truly a win-win from a tax perspective, and there are no annual filing requirements. So because it's tax-free, the IRS doesn't want to know how much money's in there. Okay, the IRS doesn't care how much money you made in the account because there's no tax consequence. So there's no annual tax filing for an ABLE account. What it's best for is smaller amounts of money. We're going to go through some limitations in a minute. Trusts can hold an infinite amount of money. ABLE accounts do have limits. So it's going to be for smaller amounts of money, but there's greater flexibility with an ABLE account than we have with trusts. Okay, one thing to keep in mind, if our loved one is going to be receiving means-tested benefits, right? So Medicaid services, if they're getting those and they were to pass away with money in their ABLE account, most states, and I got to make a caveat here, there's 46 current state plans as of 2025. Most states have in their provisions that the state Medicaid Services Office can demand repayment if the person passes away with a balance in their ABLE account. There are a handful of states, and you can review that online. We'll give you some tools you can go to do that do not require repayment for Medicaid services. So if you're in a state that does not require Medicaid repayment, that's a great choice. Maybe use that state's plan. If you're in the majority and your state does require that, you got to keep in your head, if our loved one's receiving Medicaid services, we may not want the account balance to get too big, especially if they get sick or have some additional challenge health-wise, because we don't want to have them passing away with a lot of money in there, because then the distribution is going to go back to the government. And that's an awkward situation, but it's potentially avoidable. I mentioned where you can go for research. This is an example of one of our pages on our website, oakwealth.com. Shameless plug for that. It's a free resource. You can log in, go to special needs resources. You can then compare all 46 plans in an Excel spreadsheet, compare them all side by side. Also, the ABLE National Resource Center, ablenrc.org is the website. You can go there and compare 3 side by side. So that's an easier thing to remember than Oak Wealth. Go there, do that, go to our website. We don't get any remuneration from this. We're not charging for it. We want the public to have access to it. We think it's one of the best planning tools out there for comparing ABLE accounts. So what are the basic rules? Well, the ABLE account limit, whereas the trust is infinite, is $19,000 a year from everybody. The individual can put their own money in, other people can put money in, but nobody can exceed the $19,000 per year limit. So if we have a situation with divorced parents, we've got an issue. There can only be one account. The person will have the account in their name, and there's only one. So if you got 2 parents who both think ABLE accounts are great, but they're not talking to each other, we got to work that out, because we only have one ABLE account. The first one that's set up with that loved one's social security number is going to win. That's one's going to get funded. The other one will not be allowed to be opened. So we have one account. Maximum funding is $19,000 a year. And if our loved one is working and does not have access to a 401k or 403b or similar retirement plan at work, they can add their earnings up to $15,000 to their ABLE account. Okay, nice benefit there. So they can get 20,000 plus in there if they want to put their own earnings into this savings plan. Essentially, it's created the mindset of many of our loved ones in the disability community don't have jobs with retirement plans, so they have no tax-free savings opportunity. Because in order to put money into an IRA account or a company retirement plan, you have to have earnings. Well, if our loved one can't work, they can't have a tax-free savings account. Other people can, they can't. Now they can. With an ABLE account, whether you work or not, you can have money set aside into an account that grows tax-free for your future benefit. Wonderful, wonderful tool. In addition, if you've been saving for years in a college 529 savings plan for your loved one's future college expenses, and they may not be going to college, you can take the money in a college 529 plan and move up to $19,000 a year into the ABLE account, again, subject to that $19,000 limit from all sources. Okay. Another little caveat, lots of rules here to keep in mind. If your loved one is not going to receive means tested benefits, they're not going to be on SSI, they're not going to be on Medicaid. That's my brother. He's able to work, still has profound challenges, but he's not getting means tested benefits. Then what would otherwise be a $100,000 limit for an ABLE account becomes the state's 529 college plan limit. So in most states, that's $400,000 to $550,000. That's a nice big account for my brother. If your loved one is going to receive means tested benefits, the limit is $100,000. Okay, so that's the limit at which above that number, it starts counting towards your $2,000 asset limit. The first $100,000 is excluded as being an available resource. Above that, it is an available resource. Again, if our loved one's not getting those means tested benefits, who cares? We've got a lot more room to fund these things. So kind of summarizing some of the things I just said. One account, the diagnosis of the disability must have happened prior to age 26. I'm going to assume everyone on this call has a loved one with Down syndrome. That's why they're tuning in. Last time I checked, you don't get Down syndrome later. You're born with it. Okay, so shouldn't be much of a challenge of meeting that diagnosis age of 26. There's an asterisk there because if you're working with other families and communicating in the disability community, and you find out that someone had profound disability that came in their 30s, oops, up through now, you couldn't use an ABLE account because your diagnosis had to happen before you're 26. As of January 1st, that age goes to 46. So many of our veterans who are coming back from serving the country, they come back with a profound injury. They couldn't use an ABLE account if they're over age 26. They'll be able to in the future if they're still under 46. So that's a little change that's coming. That's what I talk about. The tax laws are constantly moving around these types of benefits. Anyone can open this. The individual him or herself can open it because it's going to be in their name and they will control distributions, or other people could open it for their benefit. Okay. If the individual is participating in a company retirement plan, let's say they're working and their company has a benefit, there's a 401k available to them. If they're using that 401k plan, other people can contribute to their ABLE account, but they're not going to be able to put their earnings in there. Okay, so there's still a hard $19,000 limit. Earnings are not allowed to be put in if you've got a 401k account that you're using. Okay, so summarizing some of these benefits: easy to establish, tax-free, ignored for means-tested purposes up to $100,000. Above that, the next dollar starts to count. So if we know we're getting Medicaid services, when you get to $80,000 in the account, definitely at $90,000, start spending it down. We do not want to have a really good market in the investment markets cause that balance to go over 100 grand. Broadly defined expenses. I've not yet come up with a lot of things that you cannot spend the ABLE account on, as long as it's for the person's own use. We can't have the ABLE account paying for 10 people to go to Disney World. For your loved one and maybe one support person to go, yes, it can pay for those expenses, but not for a group of 10. It's got to be for their own benefit. The ABLE accounts have different ways of getting the money out. Most today use a debit card. So it's super easy for your loved one to have, in their wallet, in their purse, whatever. They can use that, tap and pay, and it comes directly out of the ABLE account. And there's a reporting of, hey, on this date, at this location, here's how much was spent. So from a record keeping standpoint, if you're ever to be audited, it's like, did all the ABLE money get spent for the person's benefit? Yes, here are all of our records. As I mentioned, there's currently no annual reporting requirement at the state or federal level. That could change, and good record keeping is going to be really important because they might go back and say, show me the stuff from a year or two ago. So keep your records. And for our loved ones who are more capable of managing things themselves and making better decisions, it's a great tool. It gives them independence. It's the better choice than having a credit card in the family that they add their name to, because that credit card balance is going to be an available resource. That might put them over $2,000 if there's more than $2,000 of credit. An ABLE account with a debit card, not a problem. They can use that just like a credit card most places, and up to $100,000, it's not an available resource. So super wonderful tool for giving your loved ones some autonomy, and probably the best choice among credit card type options to help them spend on what they want. What are the limitations? ABLE accounts are great, but they're not perfect. As I mentioned, annual contributions are limited. Trust accounts are not. So only $19,000 can go into an ABLE account per year. Trust accounts are unlimited. We talked about the $100,000 number a couple of times. I'll skip past that. I mentioned the disability age. We really can't focus on that enough. Really happy the government made a change here. As many things are going away from government programs for the disability community. This was a positive. There'll be more people eligible to use ABLE accounts. It really doesn't help the Down syndrome community as much because, again, all of our loved ones with Down syndrome, born with it. Investment options. Unlike a trust, can basically invest in anything the trustee thinks is appropriate. The investments in ABLE accounts are limited to typically a suite of 4 to 7 different investment choices, all of which are mixtures of stock investments, bond investments, and money market type cash investments, from most aggressive down to most conservative or just plain cash. So a little bit more limited in what you can do investment wise, but we've had families who put in $50,000 or $60,000 and very quickly found they had $80,000 to $90,000 in their account and needed to start spending it because the investments grew rapidly the last couple of years. And then lastly, there is the requirement in many states that if our loved one passes away with an ABLE balance, there's a repayment back to the state Medicaid office. So that's a negative. Okay, how are they similar to a trust? Well, these are both financial accounts at their core. The assets up to $100,000 in an ABLE account are exempt, much like all trust assets are. They're also protected from creditors. The nice thing about a trust, more so than an ABLE account, is that the only way for money to leave a trust is if the trustee decides to make a distribution. For an ABLE account, while it's protected from a lawsuit, it's not really protected if the individual has someone come into their life who finds out they've got access to $20,000 and they take your loved one shopping and your loved one buys them something. That's a problem. We can't really solve for that with an ABLE account. That risk is there. So if your loved one is more vulnerable to that, maybe susceptible to people taking advantage of them based on where they're living in their community, think about how much information you give them about the ABLE account. We want to protect our loved ones, and that could be a backdoor for someone to get access to your family's wealth through spending down the ABLE account. But again, for our loved ones who are more capable of making those decisions and want that flexibility and autonomy, this gives it to them. A trust does not. The trust requires them to make a request for something. The ABLE account, they want to do it, they can go buy it. So when many of our loved ones are impulsive, give that some thought too. Impulsivity can cause them to spend on their ABLE account pretty rapidly. That might be a negative. Okay, how are they different than trusts? Well, as I mentioned, the trust can have an infinite amount of money in it. It's not going to jeopardize any aspect of it or government benefits. ABLE account, $100,000 limit if we're getting government benefits, $500,000 or thereabouts for most states if we're not getting means tested benefits. A trust can be customized to give the trustee lots of different flexibility, investment options, etc. An ABLE account, you get what you get. The state provides the rules. If you open the account in that state, those are the rules you're going to live by. You can't change any of that language. With a third-party special needs trust funded by anybody but the individual, no payback requirements to the government. With a self-settled payback trust or an ABLE account, there's at least the risk of payback to Medicaid services. ABLE accounts, you go online, you open it, there's no cost to do so. Trusts, I haven't found a way to do a good special needs trust that doesn't cost something. There's probably some online tools. I'd be skeptical of those. We've not found one yet that we trust. You're going to hire an attorney, and that money is well spent because the attorney is going to help you get exactly what you need to provide the support for your loved one. And then distributions. ABLE accounts, as I mentioned earlier, can be spent on virtually anything and not be a disqualifying distribution. There are still some things that if you pay for them out of a trust might jeopardize future benefits. So you need to work with someone who understands those rules, make sure the trustee is familiar with those rules. And a trust has a tax return required once it's funded and has income. An ABLE account, at least as of today, has no filing requirements. I should mention that with a trust. Many times we have a special needs trust created and we don't fund it. No tax requirement required to file anything until we have it funded and it has income. Okay. What are qualified expenses? I'm going to basically skip this slide. As I've already said, you can use an ABLE account to buy almost anything. I would suggest not using it for illegal activity. That's your tip for the day. I think we all know better than to do that. But pretty much anything the person would benefit from having, you can use the ABLE account to buy. Beneficiaries. Maybe we'll finish up right around this topic. Really important. If you remember nothing else about these types of accounts, understand that we need to designate these types of accounts as beneficiary. We don't want the ABLE account to be a beneficiary of a life insurance policy or a retirement plan because likely that'll be more than $19,000. Okay, that $19,000 number is indexed, so I'm guessing next year, 2026, it'll be $19,500. At some point, it'll be $20,000. It'll keep growing, but it's nothing close to the unlimited maximum of a trust. So we want the trust to be the beneficiary, not the person outright, and understanding that our will and other documents will not control distributions from life insurance policies, IRAs, and other retirement plans. The beneficiary designation dictates that. Review it carefully. We've had families come in and tell us, I know I made that change. I submitted that. But if you submit it online and you have like a 14-character box to fill in, and you're trying to write out the Michael C. Walther Special Needs Trust dated 2025, it's very possible that that form only recorded Michael C. Walther. That's a problem, right? We want the trust piece to be the highlighted element. So if that's the case with your form, reach out to the company or the administrator and say, look, I need this trust to be the beneficiary. Help me get that into the document as the official beneficiary on my plan account. Okay, very important to do that. And then make sure that other family members know as well. Best intended relatives can screw up really good planning because they don't know to change beneficiaries to the trust. So let them know about that. So again, talk. NDSS is a great community for sharing ideas. You got to share those ideas with your broad family members as well. The unintended gift is a sad mistake. We got to then use a self-settled payback trust. Ideally, we can avoid that with good communication. Also, if we're going to pick a relative to be a trustee or a guardian or a caregiver of some sort in the future, really good idea to talk to them now. Let them ask questions about that role. If they have concerns, they don't want to do it, great that they tell you now. That's actually a gift to you if they tell you no, because then you can find someone else or some organization to play that role. Worse, you name one person and they don't want to do it. Then what? Well, that's a tough consequence. So let's make sure that we have communication about future caregivers, the estate planning work you're doing. Everybody understands this is the plan and works with you in conjunction to get the best results for your family. With that, we will tell you that we're kind of run up on the hour here. If you want this information in smaller tidbits, we have a YouTube channel that just passed 10,000 views. Lots of great special needs advice there. No sales pitches. We're not tracking who's looking at it. We want to help the special needs community get good information. Go there, look for our channel. If you want more inspirational things, just recorded another podcast this morning. Incredible people in the disability community. Lots of folks supporting the Down syndrome community specifically. We've got those industry leaders talking with us on our podcast, telling us what they've done and what they're doing going forward. A really inspirational listen for anybody who wants to tune into that on Spotify. With all of that, I may have made everything up. You can't sue us. Nothing was about your family. It was intended to help you understand more about the planning opportunities that are out there for your family and others. We hope you use it well and do benefit from it, but that's our full disclosure. You can read that at your convenience if you want to. With that, I will tell you, you can reach Randy and me anytime. We are a community resource for the entire country. We've got a box there at the bottom. If you want to use that QR code with your phone, you can give us your email address. We can add you to our monthly newsletter of updated information. So as laws change, we're telling people about it. We're helping your family stay informed about what the opportunities are. We don't use that as a chance to pitch you every month about our services. If you want to hire us, great. More importantly, we want you to be well educated and make the best decisions for your family and your loved ones. So with that, I will turn it back to Jessica if she's still there. And thank you all for tuning in. We hope you learned something today and are better equipped to assist your family with your planning.
Thank you so much, and I appreciate everyone joining us today.